court and not to punish, Your Honor, not to punish. And not to punish him before the case against him has been proved to the requisite standard of law. Further, Your Honor, in R versus Munir Haron Ishmael, High Court Criminal Revision number 51 of 2009, your brother, Your Honor, Justice Wasame, as he then was, said, and I quote him verbatim, seriatim. He said that the basic denominator is to secure attendance of the accused to answer to charges against him. To secure attendance, Your Honor, only. And lastly, Your Honor, your sister, Justice Musheni, in High Court Criminal Revision E53 of 2025, in Victor Siresia Munyao and 41 others versus the DPP, released the accused persons who are charged with robbery with violence, Your Honor, another serious charge to note, who are charged with robbery with violence on a cash bail of 30,000 Kenya shillings. 30,000 Kenya shillings, Your Honor. And Your Honor, this was further revised to 15,000 at the Chief Magistrate's Court in Thika. And therefore, Your Honor, if a capital offense that is even attracting a penalty of death sentence could be released on 30,000 cash bail and 15 further. So 15,000, Your Honor. The charge before you, Your Honor, is an intention, or rather incitement to commit terrorism. Not even terrorism, Your Honor. Incitement to commit terrorism. It means that this charge before you is an infant to the charge of robbery with violence, which is a capital offense. And therefore, Your Honor, you and I know very well, Your Honor, that these cases are coming before you, and they will still be coming. They've been coming. I know clearly, Your Honor, that this is a political witch hunt. This is persecution and not prosecution, Your Honor. This gentleman, Your Honor, does not even have a job. As a family, every morning when he wakes up, Your Honor, he thinks about the next rent, how he will get it, thinks about the next meal. This is one of the many Kenyans, Your Honor, who cannot afford 3 meals in a day. is a downtrodden, he is a less fortunate, has no means of survival, Your Honor. And therefore, Your Honor, with the wisdom that I know that you have, you possess, find it kind in your heart, Your Honor, to release the accused person on personal bond terms, or even, Your Honor, I can pay for him 5,000 Kenya shillings. I've carried it here with me, Your Honor. Because even taking him into custody, Your Honor, if we give higher bail terms, he will not afford it. Him going to custody, Your Honor, we've noticed and we've seen so many deaths occurring in these police cells. Just the other day, one of my constituents was murdered in a police cell less than a week ago. A gentleman by the name Bernard Omai died in a police cell, Your Honor. Today, Kidero, again from my constituency, Your Honor, has been brought before you with incitement to terrorism charges, Your Honor. I don't know what might happen to Kidero if he is not released today, Your Honor. He was arrested 2 days ago. We tried to talk to the officers to release him on cash bail, on bail, the police bond, at the police station.
When was he arrested?
He was arrested the day before yesterday, that was on Tuesday, Your Honor.
Tuesday the 26th?
Yes, Your Honor. The manner in which this innocent person was arrested, Your Honor, you would think that it was a movie, Your Honor. 6 Subarus, 15 police officers, 15 guns, fully loaded, Your Honor. And we wonder that there's still insecurity in our country, Your Honor, with that kind of machinery that we have. Therefore, Your Honor, as I rest my case, Your Honor, and invite my learned counsel, it is my prayer that you deliver your ruling extempore, Your Honor, and consider this deserving citizen. I rest my case, Your Honor, and thank you for your time.
Thank you.
Good afternoon, Your Honor.
Yes.
My name is Onjira Maya, and I wish to fully associate myself with the submissions that have been made by my colleague, Counsel BABU. But I also wish to expand the debate here. Section 123A of the Criminal Procedure Code directs this court on what it should be considering when an application for bail is made. In addition to what Counsel BABU has very eloquently explained to the court, that the first and overriding consideration should always be...
That is section
123A of the Criminal Procedure Code. So in addition to what Counsel BABU has very eloquently submitted on, which is that the first and primary consideration should always be whether the accused person is going to avail himself of trial. It is also clear that first and foremost, the relevant circumstances in the situation should be considered by the court. The nature and the seriousness of the offense must be considered also by the court. The character of the accused person, the accused person's record in respect to fulfilling previous obligations, if there were, and the strength of the evidence that he or he may not have committed the offense. Your Honor, I am anticipating a situation where the ODPP is going to very seriously compel you that the charge before the accused person or the charge facing the accused person is serious. And that is what I would like to dwell on in my submissions. First and foremost, Your Honor, is the right to be presumed innocent, which guards against bail and bond terms that are or may be exceptional or that may be couched in a way that would lead to pretrial detention. We pray that the court considers that at this point the accused person is presumed to be guilty. There is a requisite standard in law that the accused person is to be presumed to be innocent. I stand guided, Your Honor, is presumed to be innocent. But there is a requisite standard in law that the ODPP is supposed to fulfill as regards the charge before the accused person. But more importantly, Your Honor, is that Justice Onyego of the High Court in Republic v. Ali and two others, this is criminal case E002 of 2024, in paragraph 15 and 16, and we pray that they guide this court.
The full request number?
E002 of 2024. We pray that the court considers first and foremost that the High Court has supervisory jurisdiction over this court. But in paragraph 15 and 16, the learned judge postulated as follows: that first and foremost, the mere fact that an offense carries a severe charge, a severe sentence, is not reason to deny bail, and it is not also reason to couch bail terms in a manner that would lead to pretrial detention. That is one. But secondly, bail is simply security to ensure that trial is attended by the accused person and is not going to be based on the seriousness of the charge. It is also not going to be based on the seriousness of the sentence that the accused person stands to serve if he is convicted. So that is first and foremost. And the same position has been taken by the bail and bond guidelines that have been prior mentioned by Counsel BABU, that seriousness of charge is not by itself a factor to warrant denial of bail or to couch bail terms in a manner that would lead to pretrial detention. Your Honor, this is guideline 4.26 of the bail and bond guidelines. Further, on the question of presumption of innocence that I had alluded to under Article 50, Sub-Article 2, the bail and bond guidelines under Guideline 3.1 are clear that bail is supposed to